I'm back.
I don't see my image on the screen.
You're there. I can see you.
We can see you, Judge.
There I
Yes,
am. Okay.
I can see.
All right. So what property are we talking about?
We're talking about a license and an access for Calypsdorp and MDUC. There's electronic data. He took a server out, a computer server, and I guess he needs to keep that because it does have Nixon engineering on it with everything else, but she can't. And what we're specifically talking about is electronic data, license and access to get into Calypsdorp and MDUC, all of those electronic files. We're also talking about loan electronic codes to get into a loan that was taken out in favor of Calypsdorp, not a PPP loan, but it was one of those government programs, and she can't access it to pay it. It's a $100,000 loan because he took the server that had the electronic codes and the data for her to access those things.
The server is owned by Nixon Engineering. And this is literally the first time I'm hearing about these things being needed. I don't think that it was discussed in the hearing, and I believe that the transcript's very clear that the judge only ruled on files. So I would ask that the order not say property. I am happy, Mr. Jenkins, because I agree with you under the temporary orders, your client's entitled to those things, but I don't believe that it's appropriate to put them in the order. So we will, it's a holiday weekend, but that the first when we return to the office next week, we will absolutely work on getting all of that to you very quickly.
And I take her at her word, Judge. I think if you think this is something that I'm wanting to come back to Judge Langley on a motion to enforce over the word property, you're mistaken. I'm not that brave. So we're just want the things put back that were removed in reference to Calypsdorp and MDUC.
Okay, well, in an enforcement action, you have to be specific. And I'm going to eliminate the word property and, because that's all, only thing I remember anything about is files in that. And so I'm not going to make any orders. Y'all can do a Rule 11 agreement pertaining to those licenses and access to that loan. I'm not going to go back and redo the evidence in the hearing if there wasn't anything put in the
Yes,
hearing itself. Okay.
Yes, Judge.
Yes,
The next issue, Judge, is the order on the bifurcated trial. You ordered that I prepare the order. I prepared that and sent that over to Ms. Nguyen on June 7th. And then on June 29th, I received from Ms. Nguyen's office a different draft. And I'm gonna show you my draft. There's, let me share the screen. This is the order that I drafted. We are in agreement with the first page, I believe. Where it gets sticky is that they agreed to A, B, and C under the findings, but they have, it appears when I compare their order with mine, it appears they struck D through K. And then they have, in the order section, they have the first two sentences, but they struck the last two and then they entered some additional orders in their proposed order. So it makes it a little complicated because they have a different version. I also included a quieting title section because we did plead quieting title. That's one of our causes of action, and the court ruled that the deeds were not gifts and they were void or voidable, that the statute of limitations told based on fraud or duress, and that they're also voidable based on fraud or duress. We would then have to, once this order is entered, to clear title, we have to then take your order and file it with the county clerk so that there's actual clear title on Mr. Nixon's separate property. In the further temporary order, you acknowledged on page 25 of the transcript that even Miss Nixon could enter additional contracts to sell her contiguous property related to the Pecan Street properties. That would be 801, I think 501 Pecan Street and 809 Emile. Those separate property tracts were in this gift deed. And so that's kind of where it gets conflicting. I'm under the impression that you intended to clear title for all the parties' separate properties by your ruling. But Mr. Jenkins has indicated that they do not want there to be clear title until this case is completely finished, until there's a final ruling or a mediated settlement agreement on file. And so that's just giving me heartburn because Mr. Nixon, all of the properties that were their separate property, it's not like he can go take out a loan to even pay attorney's fees or to get money for the IRS if we don't quiet the title now. And so that's why I'm asking, based on the ruling, that we enter this order, specifically in your transcript related to this ruling. If we look at, do you want me to pull up your transcript, Judge? Would that assist you?
I have not.
Okay. In your transcript, and this was been pre-marked as petitioners 3, and I would offer this to be admitted. Mr. Jenkins, do you have an objection to the admission?
Well, I mean, I don't know what that is. I'm assuming that I trust that that's the transcript, Judge.
Yes. Yes, sir. I apologize. It's the bifurcated trial court ruling from May 12th.
And how many pages?
It's 6 pages.
Judge, I have no reason to believe that that's not the transcript, so I don't have an objection.
All right, petitioners 3 is admitted for this.
Your Honor, you had stated that you didn't find that the evidence was sufficient to believe that it was a gift deed, either one of them. And so what I did in my proposed order was that I stated that I attached each of the deeds as exhibits, and I stated that neither was a gift deed. And Ms. Wynn tracks that language, so I believe she's in agreement on that. Where we go cross is on D, I state that the September 11th, 2013 deed is void, because in your ruling, you state that I find that the deeds in question are void. And so I say that deed 1 and deed 2, the correction deed, are both void. And then I state that if the statute of limitations is applicable, it was told due to fraud or duress in the next 2 sentences, which is based on your next statement that you find that the statute of limitations, if it was applicable, was told by either fraud or duress. So I write that in there. And then, oops, sorry. And then I state that it was voidable for fraud, and that it was also voidable for duress. And so I attach the deeds, and I state that the court finds that it was either voidable due to fraud or voidable due to duress committed by Ms. Nixon. And then in the order section, I just order all of those findings. I think it's Mr. Jenkins and Ms. Wynn's position that these are findings of fact and conclusions of law. I believe that these are very basic findings for this specific order. I still think that if the court is requested to do findings of fact and conclusions of law, that they would actually talk about the evidence that was presented. And in my order at the very end, I did take Ms. Wynn's language, and I'm agreeable to putting it in here that the findings of fact and conclusions of law with respect to this issue not be addressed until the final ruling on all aspects of this divorce are made by the court or agreement of the parties. I'm fine with including that so that it's clear that this issue can't be appealed until the conclusion of the case. I think that Ms. Wynn initially thought she might appeal right now, and I think they agreed with me that it's not something you can appeal till the final ruling. But I still believe that at this time, it's appropriate to enter an order that does contain all the findings that were made in this bifurcated trial and a portion that quiets the title for these parcels because there's already been a ruling on this issue. And so that's why we're asking that the court enter our draft. And I'll stop sharing the screen and allow Mr. Jenkins to speak to theirs.
Mr. Jenkins?
Judge, looking at your transcript, you state on page 3, line 19, and there will have to be findings of fact and conclusions of law prepared to support the court's findings in that regard. But that essentially does not have to be done until the end of the case. What Ms. McClyman is attempting to do is draft an order that has the effect of a final order by quieting title and including findings of fact and conclusions of law. But Ms. Nixon is being denied her due process because while it has the effect of a final order, she can't appeal it. It's not appealable. Your ruling on page 4 goes on to say, the court, all right, you'll need to prepare an interlocutory order that's consistent with the court's findings. Ms. Wynn has drafted, and which is titled and forwarded to Jennifer, an interlocutory order that says, very briefly, what the court's rulings were, but we're asking that you carry, she's also prepared a letter and forwarded it to Jennifer for your review, to carry, as you said you could in your ruling, the issues of findings of fact and conclusions of law until the end of the case, when Ms. Nixon will be able to avail herself of due process and make a decision whether or not to appeal at that time. But we, if you decide to sign Ms. McClyman's order, we'd ask that you strike their findings with regard to quieting title, as that issue is not ruled on by the court. And 2, that you include language that the interlocutory order has no force or effect until the final decree has been signed by you. And 3, that you order the case be sealed immediately, because there are these findings of fact and conclusions of law have some bad, some words like fraud that gives us heartburn. And we would prefer that you sign Ms. Lynn's order, but if not, we'd ask that if you prefer Ms. McClyman's order, that you strike the findings with regard to quieting title, include that it's interlocutory and has no force or effect until the final decree has been signed by you, and that the case be sealed.
This is the first that I'm hearing. This is not in the draft that I received. The draft I received on June 29th did not have a request that the court seal the file. That's not something that was requested before. And I also have an issue with the court entering something that says that the order will have no force or effect until it's incorporated into the party's final decree of divorce, merely based on the fact that I thought everybody understood, and from the court's transcript from the hearing on May 13th in the further temporary order hearing, people acknowledged that Ms. Nixon could sell her interest, her separate property interest in some of the downtown properties while this case was pending because it's separate property. Those properties were in these gift deeds. So if that's the case, she can't sell assets either. And that's kind of like, I guess I need that to be clarified at what the court's expectation is with respect to the separate properties. But I'm not in agreement with there being language about the file being sealed. I don't think that that's been pled or requested, and I don't think the court ordered that.
Okay. As I understand it, Ms. McClyman, what you are wanting to do is to enable your client to either encumber or sell these properties. Is that correct?
To encumber them, yes. He was trying to get loans with the bank,
Okay.
not sell. We're not trying to sell those separate properties.
Well, because this is an interlocutory order and is not appealable at this juncture, you would have to get their agreement to encumber this property.
Okay.
And if there was an agreement to encumber, you would in effect have the ability to put an encumbrance on the properties before there was a final resolution, because nobody else has any interest in any of these properties, correct?
Correct.
Because this is interlocutory in nature, I tend to agree with Mr. Jenkins that the quiet title issue should not be included in the ruling.
Okay.
There should be specific language stating that this is an interlocutory order and it will not become final until the case becomes final.
And so, Judge, if I can show you what I was going to do then is the last two paragraphs in Ms. Wynn's proposed order about the findings and the interlocutory order. If I delete out my quiet title section and then I add those two paragraphs in, does that, I can share the screen and show you. So
Yeah, because if I'm incorrect and an appellate court decides that I have totally done wrong, then I don't want the properties to be encumbered between now and then.
understood.
Okay.
Yes, sir. With respect to the other, just the findings that track what you found on the record, that would be D through K that Miss Wynn had an objection to. Is it okay that I leave those in as long as I take out the quiet title section?
Yes, ma'am. And include that language that it is an interlocutory order.
Perfect. It's the highlighted section, and I'll just unhighlight that and then turn this into a PDF and send that over.
Okay.
Judge,
I think that's appropriate.
Judge, are you going to carry the findings of fact and conclusions of law about the fraud until a final hearing?
I wrote that in there, Mr. Jenkins. What Ms. Wynn wrote, I put in here.
But your order still contains them, correct?
Well, it's necessary to the determination of the fraud and duress issue. So I think it needs to stay in the order.
All right. Is what about a request then that it be sealed in some manner?
What's the concern?
Ms. Nixon's concern is that it is not a final appealable order, and yet there's a record of fraud by her and duress, and those are words that she would rather not have the public have access to when she can't do anything about it, she can't exercise her due process rights to appeal that or have that changed. Yet there it is in the file for the world to see.
Well, it would appear in the final order for the world to see. What is the harm that's going to occur between now and then?
The only harm I could see it cause is harm to a possible settlement. You know, if it's not made public, you know, it's certainly always my intention to work a case out, but I just see it as a barrier to that, something that she'd rather not have included in a document that's public record.
I think that
Is there any harm in sealing it?
I think there is. I mean, the public's entitled under the law to it unless there's actual grounds, and there's a standard for that, and it's not been pled yet, so we would object.
Well, but it's not an appealable order. We can't do anything about it.
I would have to take a look. It's Rule 72 or 78.
Yeah.
Something like that establishes the standards for what cannot be sealed without notice to the public.
Correct.
Well,
I don't have that handy here. I can look it up.
and Judge, just looking at the transcript, again, you did state that there will have to be findings of fact and conclusions of law prepared to support the court's findings, but essentially that does not have to be done until the end of the case.
It's
And
76. I'm sorry.
And that's our request, is that
What does 76 say?
I have not opened it yet. But it's about here. Let me share the screen so everybody can, if I can. Too many buttons. Sorry. 1 second. Okay. So they have to, upon a showing,
that 76A,
yes. I'm just not prepared to argue this at this moment. Would be my position that they're more than welcome to file a motion and set a hearing on it, but I would like time to be able to prepare to argue against the request. But those were the findings of the court at this time, and based on my experience with Judge Langley, I would imagine he's going to do a fairly detailed finding of fact or conclusion of law based on the case law and the evidence. That these are just the basic findings that we put on in typical orders, and not the actual evidence that supports the findings. But I would ask that the order just be entered the way it is and not sealed until there's time to have a hearing with notice over it on the issue of sealing.
and our response, Judge, is just in your ruling that it didn't have to be done until the end of the case. And we certainly have no remedy at law or in equity to do anything about it until the end of the case. And we're asking.
I don't understand what the specific, serious, and substantial interest that is at play here.
Well, my response is that procedurally, she's denied her due process. She can't challenge this order, and these findings could be carried until the end. And it seems like the much simpler solution than sealing. I can tell that maybe the court isn't inclined to seal it. We would ask that those findings be carried until there's a final order that is appealable, and that then she could not be denied any due process and have her legal rights to challenge it if she chooses. She just can't right now. Why
Well,
not
first
leave
off,
those?
I'm not denying anybody due process. We had notice and we had an opportunity for a hearing, and you had the opportunity to present your side of the story. Nobody's due process rights have been denied. You just don't like the ruling I made.
Well, maybe you're right about that. I'm certainly not saying her due process rights are being denied. If I came across that way, I apologize. That's not my intent. But I am trying to protect her from an order that has any effect of a final order that she can't do anything with, especially if it doesn't hurt anybody to carry those findings until a final order. I don't see the harm in that.
Isn't that what the last paragraph that was added says, that it's interlocutory?
Correct.
Yes, sir.
Is there some concern about her law license?
I don't know if that's one specifically, but I'm sure it is when the, the fraud, duress, coercion. I think there's a lot of concern in her mind about what that could mean.
I mean, that's something though, if somebody saw this and got it from the general public and then gave it to the Bar Association, they're going to wait to have any type of hearing till the conclusion of this. And that's not the only thing they look at. They know this is a divorce case. And so that doesn't mean that they're going to act on it immediately.
But what is the harm in leaving it out for 9 more months until?
Well, because the public has a right to view any order that is entered by the court. That's
yes,
what Rule 76A says.
Yes, sir. And I was kind of steering away from sealing and back to just carrying those findings until a final order. A final appealable order can be drafted.
Okay, I can do that. We'll take the fraud and duress allegations out of the order, and we'll refer them back into the findings of fact and conclusions of law at the end.
So, okay. Can we have that reflected in the order? I'm concerned that it then cuts the teeth off of the order. I mean, at this point, then I'm worried about appellate issues with this bifurcated ruling, not in containing the actual ruling. So is the,
if it's going to be appealable, you have a right to findings of fact and conclusions of law, and you can demand that if it is appealable. It's not essential to the order because the court is finding that it is not a gift.
But that's a totally different, there's 3 different legal standards that I had to prove. Those are separate. Like the gift, that it's not a gift, is separate from the grounds that I have to establish for you to find that it's void, and totally different from the grounds that I have to establish for it being voidable. I had to prove totally different elements for you to reach those conclusions. And so for all the case law I've read, I have to have specific findings that how you reached those that ruling. And that's why it's completely different whether it's a gift. Whether it's a gift, I agree that it wasn't. But if the Court of Appeals strikes and says, wait, no, it was a gift, and then they want to look at it, well, was it void? That's a different way in which they could throw it out. And then whether it's voidable and whether the statute of limitations came into play is also another reason in which they could uphold it or not uphold it.
You include the finding that it is void, and in the event it's found to not be void, it is voidable, and that the specific findings of fact and conclusions of the law will be entered at the end, or language to that effect. It doesn't require findings of fact in an order. Simply making a ruling about what the court is doing on your motion.
Correct. I didn't, other than put the finding that the court made in its transcript on the record, I just literally copied what you found on the record and put it in the order as the basis for how you ruled.
And that will form the basis of any findings of fact and conclusions of the law that are entered at the end. They don't have to be entered in the order.
So I want to make sure I understand that I'm writing this the right way. So instead of saying the statute of limitations, if applicable, was told due to fraud committed by Tina, Tyner, Zavalak, Nixon, you would want it to say the statute of limitations, if applicable, was told, correct, period.
And that would get you where you need to go. It just needs to be found to be void, and in the event it's ultimately found to not be void, then it is voidable as an alternative.
Judge, I would suggest that we look at Ms. Wynn's order, which says exactly that.
No,
I know, Caroline, you want your order signed.
I literally have it pulled up right now and I'm editing it, Mr. Jenkins. And so that's one of my issues, and why I wanted to ask for attorney's fees, is because I drafted an order. Y'all refused to redline it. It's very frustrating.
That's not true, Caroline.
Okay.
Okay, I'm not gonna go there. Y'all can fight on your own time.
Judge, on G, it says the deed dated and attached was void. So you would just want me to delete the due to fraud section, correct? Otherwise,
yeah, just eliminate the findings of duress and fraud.
Got it.
And then we'll include those in the findings of fact and conclusions of the law.
Understood.
Okay.
Yes. I'm just making sure.
And we're not going to seal this order. It's going to be a public order.
Okay.
Because I don't think there's anything in this order that the public should be denied any access.
And then, so for right now, it's B, C, D, E, F, and G, and H. That's taken out the language about fraud or duress, and I'll make the order section reflect the same. And then I will send that over, and I will include Mr. Jenkins and Ms. Wynn on that email.
Well, the statute of limitations was told, you just take out the due to.
Got it. Is voidable. Got that. Is voidable. There we go. That should cover it. So now we just have that it's not a gift deed, that it's void by operational law, the first one, the second one, statute of limitations, if applicable, was told, and then both deeds are voidable. And then we have the language about findings of fact, conclusions of law with respect to this issue, not be addressed until the final ruling on all aspects of this divorce are made by the court or agreement of the parties, and that it's ordered that this interlocutory order will have no force or effect until it is incorporated into the party's final decree of divorce and said decree is signed by this court.
Yep. I think
Perfect.
that's appropriate.
Okay,
I can
Then
sign that.
I will forward that. Judge, do you want me to send this to Ms. Reeves for her to forward to you? Or do you want to?
You can just go ahead and send it directly to me and I'll send it back to them to be filed.
Okay. Will do.
All right, what else do we have today?
I just need to see if we can schedule a hearing on our motion to, I think it's to remove Dr. Thorne as the custody evaluator and appoint a new one, and a motion for further temporary orders. Dr. Thorne has sent us a letter of resignation due to a conflict of interest with Miss Nixon. And so we are needing to get a new custody evaluator appointed. Judge Harger said he didn't want to complete mediation until the custody evaluation was completed. And so we're kind of now at an impasse until we can get a new custody evaluator appointed. We can't get the custody evaluation done in order to have mediation. And so I'd like to get a hearing at least over that brief issue.
Mr. Jenkins, what's the holdup on the custody evaluator?
Well, that's with the order, with getting a new order signed.
Yeah.
It was a notice problem. First of all, Ms. Wynn could not be available today. And so I'm here handling this. And if we're going to talk about dates, usually you ask Ms. Ensinger and she gives us dates and everybody confers, and it's going to be difficult for me to confer. Maria is here and Mike could check dates. I don't recall, this stuff was filed at the beginning of this week. And I just don't believe there's been enough time to look at everything and get there when we were fighting over these orders. Ms. McClyman filed them either 3 or 4 days ago at night and late at night. And we just haven't had a chance to, obviously we need a new, we've agreed on the person. We've done some work on it. But
How long is it going to take you to figure out if you're going to agree on a custody evaluator?
We already agreed on an evaluator, Judge, and I sent a proposed order the day that Dr. Thorne resigned, but Miss Nixon had hand edits on the order that I proposed. I literally took the exact order that you signed before.
That's not true.
Mr. Jenkins, I added one component to do a parental alienation assessment. And I told Mr. Jenkins if that gave them heartburn, we could take that one sentence out. And they said it didn't bother his client. But Miss Nixon wants to include language about, she had several edits to my proposed order. I tried to work through this last week with Mr. Jenkins. That's why I felt pressure to file something, because I want to get the ball rolling on this. She wants to change the language on how the custody evaluator is paid. She wants to have additional evaluations into medical conditions and ask that the custody evaluator make recommendations that the court order medical treatment, which is illegal. So I can't make those agreements. Like, I just want the order you signed before to, like, we can white out Dr. Thorne's name and slap in Dr. Ainsley's name, who we've agreed to. It should not be this complicated.
One of the issues is payment, Judge. These things are not cheap. And at the time of the first custody evaluation was entered, there was a talk about getting a loan. A lot of things were going to happen. Mr. Nixon was going to do lots of things, none of which happened. And that's how the money was going to be used to pay for these custody evaluators. She gets $7,500 a month, and now they're wanting it to be split in the first order. Caroline, that's right. That's what it said in the first order. Then it said community funds. So there's a concern about how is she going to pay for this. Mr.
Will, it's
Nixon,
in the order. It says it comes out of the sale of the condos.
Caroline, I didn't interrupt you when you
Sorry.
spoke. I would request the same respect.
Yes, sir.
The concern is, how is it going to be paid? The other concern is Mr. Nixon had already paid plunk down over $10,000 or $10,000 to go talk to Dr. Thorne and had already been speaking to Thorne without us knowing anything about it. There was, I think this can be worked out. To answer your question, Judge, that you asked 15 minutes ago, we just need some time, a little bit of time. This is not something that we should be wasting the court's time with.
Well, you're running out of time because I'm not going to let this thing go on forever. I had intended to talk to y'all about getting a final hearing date set in this meeting, because y'all are not going to, I'm not going to do any more temporary orders hearings. I'm not going to do anything other than something that is just an outright emergency. We need to get this case resolved and get it done as soon as possible, because y'all are just losing money. You're bleeding money, you know, out of this family, not for lawyers' fees. It's just, you can't manage a business over a long litigation and expect it to be profitable. Y'all need to get a final date and get this divorce over with so that everybody can move on. Now, I think we've done as much as we can to get everyone access to the information that you need. We just need a date, and I need to know how much time y'all need to resolve this case.
So, Judge,
in front of a court.
just so you're aware, I have a letter of deficiency I've been working on, that's gonna go out, because we don't have any of Miss Nixon's bank statements and we don't have access to them. And during her deposition, she was instructed not to answer questions because there was a custody evaluation that was ordered. And so we would like to just have the order you signed before for Dr. Thorne, have the new evaluator's name put in. You just are about to sign an order about the condos being sold and the downtown Bastrop properties being sold and the proceeds paying the custody evaluator. My client borrowed money from his parents. The court had ordered the parties to go to Dr. Thorne within a certain date time frame. My client contacted Dr. Thorne. He paid a portion, he borrowed money to do so. Miss Nixon, it's not our fault that she didn't contact Dr. Thorne. We just wanted to, now that he's resigned, we want the new person put in place. We want to start this process so we can get ready, go to mediation, and then have a final trial. But I want you just to be aware, I'm likely going to have to file a motion to compel if we don't get documents from Miss Nguyen.
Judge, I think by next Wednesday, I should be able to have the order with the new custody evaluator worked out with Ms. McClyman. Is that quick enough? Or have an answer that we can't, but.
Okay, that doesn't answer my question. When do y'all want a final hearing date?
I would ask that, I would think if we're gonna have custody evaluators and business brokers and evaluators coming in, that would need to be a 10, I don't want to say 10 days, but it took us 2 days just to try the property thing. I would think that we would need at least 5 days. And
But when?
I'm getting to that. If we're doing a custody evaluation and she said that we can't start until the end of July, that would put that out 3 months. So that's October. And then on top of that, I'm taking board certification in the middle of October, and then we've got holidays. So I would ask that it be set at the beginning of January if possible.
That's too late. this family can't survive that long. They're gonna go broke. We'll be getting into bankruptcy before then. And if you ever want to see something that drags a divorce out, bankruptcy is one of them. I think we can't wait longer than October. And I'm already getting scheduled. My calendar is already now getting scheduled in October. I would, Jennifer, are you there?
Yes, sir.
What does it look like in the week of the 18th of October?
I'm sitting for a board certification that day.
All right, the next week.
We have actually, I think Haley is scheduled out. We would need to look for a visiting court reporter. October 25th. Is that right, Haley?
Yes, ma'am. That week I won't be available.
I believe she's doing Mr. Morris's jury trial that day. Mr. Morris has a jury trial in the district court. I don't know if Haley's helping with that. No? Okay.
No.
Okay. Well, what about November the 1st?
That's just a normal scheduled week of court for the county court at law. I could, let me see what,
We could do it out at the law enforcement center. If we find a court reporter.
I could work on looking for a court reporter. You said the first week of November?
Yeah, is there a week in November that is better for your court?
We have a jury week set aside with no jury set at this time. That could change. I just won't know until, but that week is November the 15th through the 19th.
Mr. Morris has a jury trial that week. I can do the week of the 1st or the 8th or the next week's Thanksgiving. I'm available the first two if we can find locations. Mr. Jenkins, are you available the first 2 weeks?
I'm available either of those times, and I'm hoping Maria Sanford is on, that she is checking her calendar for Miss Wynn, and I'm hoping that she will speak up here shortly.
Yes, she's available.
The second week of November, it looks like Veterans Day falls
On Thursday.
Thursday, and I do believe the county is closed that day. The first week of November, the 1st through the 5th, was there a conflict with that?
The concern was the court having its regular docket that week.
And if it's going to be at the law enforcement center, I'm going to need to speak with Mishka and Deborah about courtroom availability. This is going to be a 5-day trial. Is that what you guys were saying?
That's what I heard.
I haven't gone through witnesses, so 5 days is going to be tight. That's my concern.
All right, we'll just tentatively schedule it for November the 1st for now. And see if you can, Jennifer, see if there's any problems with that date and coordinate that with the lawyers. I'll go ahead and block that whole week out on my calendar. Okay.
Judge Langley, if we can't get an agreement on this custody evaluator order, can we just give you, like, if I do a submission with my draft and Mr. Jenkins gives you a submission with his red line edits, can you then just take it up on submission and then tell us what you want to do?
I have no, I'm sorry, Judge.
Is that all right with you, Mr. Jenkins?
Yes, sir. No objection to that.
All right. That issue will be taken up by submission and just give it the proper notice.
We're going to attempt to get an agreement first.
Yeah, if we can't, then by next Friday morning, we'll just submit it to the judge, right? Does that work for you, Will?
That's fair. Oh,
I don't think I can honestly and fairly allow this case to go on past November. So I don't think the family assets can survive that long. And we need to do something. Okay?
yes, sir.
Judge Langley, I'm going to get with the district court to see if we have availability at the law enforcement center. And then I will get back in touch with you about courtroom space.
I'm just letting everybody know I blocked that week out of my calendar.
I think we could make something work. Maybe it's not ideal, but there's a third floor courtroom in the right above Judge Eskew's courtroom that it's not ideal for juries for sure, but maybe a bench trial. I don't know. I'll check with them too.
Okay.
The commissioner's courtroom too. I don't know if that's an option, if they're not doing commissioner's court that week.
Yeah, the question mark is whether Haley could be there, or we would have to get another reporter.
Well, we might have to get another reporter. I mean, Haley is scheduled for the county court at law, but if it would be better for her to be with this case and us get a visiting reporter Tuesday and Wednesday, we could do that.
I'll leave all the details to you, Jennifer.
Yes, sir.
Okay.
Yes, sir.
And I'll await submission of the final or the order that has been revised by today's hearing. And I'll await submission of the issue of the revised order for the child custody evaluator for next week. How are we doing on getting those properties down in Corpus or Padre Island?
Puerto Riensis. We are waiting on we're waiting on Miss Nixon to clean and stage the 2 condos so that they can be photographed and listed.
And my last communication to Ms. McClyman on the issue was that it was her great hope that she would be out by end of the day Monday and then ready for the realtor to put them on MLS.
Okay. Well, anything else today?
No, sir.
All right. Do you have anything else, Jennifer?
Yes, I do have a question. In the event that the law enforcement center is not available every day, would it be, I know it's not preferable, but would it be okay if maybe a couple of days at the law enforcement center and maybe a couple of days at another location, depending on what everybody's schedules look like?
I don't anticipate that this is going to be a case that has a lot of bells and whistles that we have to deal with technology on. So I think we'd be fairly mobile in our ability to move from different courtrooms.
Okay, all right.
It just took us 6 boxes of paper though to do the bifurcated trail. That's my only concern is like, I think more than 6 probably, but we will try to accommodate whatever is needed.
Well, I mean, it would be, you know, maybe a couple of days. Are you talking about transporting your case?
Yeah.
Oh,
Yeah.
well, it'll have to be transported whichever location. So
I'll help her carry her bags.
Thanks, Will.
okay. Okay, I will let everybody know.
Thank you.
Thank you.
All right.
Okay.
Just in case we need additional time, I'll go ahead and block out the next week as well if we need some adjustments.
Okay. I'll do that as well, Judge.
Okay.
Thank you.
All right. Now, anything else?
No, sir. If it's all right with you, may we be dismissed?
Have a good 4th of July.
You too, Judge.
Thank you, Judge. You too.
We're adjourned.
Thank you.